Hey, good evening. I'd like to welcome everyone to the City Council joint work session of Thursday, March 5th. Call the meeting to order and ask for approval of the agenda.
So moved.
To approve the agenda. All in favor?
Yes.
Yes. Okay, is there anyone besides us that would like to make public comment? Anybody online? No? Okay, so we'll move right along. So this evening, we're going to get land use training with Missy Ryan, who I finally met in person tonight. And when she's giving her presentation, if you have questions, she would like you to ask them at that time, not to wait. So you don't forget what your questions are.
As she goes.
As she goes along.
Thank you.
Okay.
Who could remember until the end? And can I just ask, Mayor, do you want to recognize people as they have questions?
Sure, just throw something at me. Okay, you ready?
Okay, thanks for having me here. It's so nice to meet so many of you in person. I know the planning commissioners that are here. You guys don't really need the training because this is your wheelhouse, but thanks for coming. So a little bit about me, Missy Ryan, and I am with the law firm of Bateman Seidel. You are familiar with my partner, my former partner, Bill Weissman, and my current partner, Terry Richter. Bill is happily retired. I had a beer with him last week, and I can assure you that he is really enjoying retirement. I've been practicing law for 27 years, and for the last 20 years, roughly, I was a board member or referee on the Land Use Board of Appeals, which is LUBA, which I know you're all familiar with and love.
Unfortunately.
Yes, and prior to that, I was in private practice for 8 years. And most of that time, about 6 years, I was with the Miller Nash Law Firm. And then a couple of years, I went to a smaller firm before the governor appointed me to LUBA, where I stayed until I joined Bill and Carrie. We represent a lot of small cities in Oregon City, a couple more coastal cities, Nehalem, Wheeler, we represent the city of King City, the city of Sherwood on some matters. Mostly we're a special land use council, but we do some as general municipal work for those cities as well. I really love representing smaller cities because you're under-resourced, but you have the same issues as the larger resource cities, just less money to tackle them. So very excited to be here. We do these land use trainings once a year. I know many of you have been through these trainings every year, but even when I'm preparing the materials, I always find something that surprises me that I had forgotten about or I didn't know. And in Oregon, land use is an ever-changing world. It's a different kind of law than perhaps real estate, which doesn't really change that often. I can't really cover all of land use tonight in an hour, but actually maybe 50 minutes or so. But if there is interest, we could, in a particular topic, I can always, come back and I can do land use 201, and then we could graduate to land use 301. So with that, we talked about, please don't try to hold your questions. I could never do that for an hour presentation either. So the purpose of this is to talk about your roles as representatives of the city and the process of what you do for the city with respect to land use. I threw in a few public record slides at the end, just in case we had time. Probably not going to get to that. So if I could have, go to the next slide. Okay. So big picture, if we step back, how is it that cities even have the power to zone and to regulate the use of land? Well, it comes from the big kahuna, the US Constitution. The 10th Amendment gives the cities the police power, which doesn't mean law enforcement power, but means generally the power to regulate health, safety, and welfare of its citizens. And so that is where the power to zone comes from. And this is an interesting fact that I stumbled on. In Oregon, cities were first authorized to create planning commissions in 1919, which is, more than 100 years ago. So our land use planning framework is a building block system where the city doesn't directly apply, for example, the US Constitution when you're making your land use decisions. Usually the city will implement state statute. State statute is generally consistent with the US Constitution because the legislature is required to comply with the US Constitution. So you're implementing the law through your comprehensive plan and your land use regulations. Mainly that's Title 17 of the Cannon Beach Municipal Code. So this is why when we're in a land use hearing, we don't have to pull out our pocket copies of the US Constitution, because that's all taken care of. That's not to say, though, that the Constitution isn't an overarching principle, and it does apply directly in some circumstances. Mainly that is with respect to the Fifth Amendment, the Takings Clause, and also the 14th Amendment due process clause, because in certain land use proceedings, we want to provide some procedural due process to the participants. Also, a few other, sometimes First Amendment principles come up. That is generally free speech. Sometimes it's freedom of religion. Those can all also come up in land use proceedings. Also, the Fair Housing Act and the Americans with Disabilities Act are potentially applicable or can be issues of concern. So at the state level, I think you're all aware of this, but I'm just gonna go through it quickly. There's a state agency in Salem called the Land Conservation and Development Commission, and they are charged with being the overprotectors of the land use system in Oregon. They do that through the Department of Land Conservation and Development. So we have LCDC and then we have DLCD. And land use, like many areas of law, is full of acronyms. So the main thing that the LCDC does or did is adopt the statewide planning goals. And there are 19 statewide planning goals. Once the statewide planning goals are adopted, the city went ahead and many years ago adopted your comprehensive plan. And the comprehensive plan is consistent with the statewide planning goals. Once the comprehensive plan is blessed by LCDC, the goals fall away from most everyday land use decisions that are made. And so that's why when you are reviewing a staff report, for example, for your very typical kind of land use decision, the goals don't come up and they're not referenced in the staff report. And that's because the code and the comprehensive plan already comply with the goals. In legislative decisions, however, which is when you're amending your comprehensive plan or your code, for example, the recent STR amendments that I think are under discussion, those do need to show goal compliance. Because that's a direct link between the goals and the comprehensive plan or the land use code. It's slightly more complicated than that, but that's how I'm gonna leave it. And so let's see.
Can I ask a question?
Yes, please.
So just to be clear with what you said just now, we as a planning commission, for instance, I'm speaking from my perspective. If we are presented with an argument related to statewide planning goals that seems to be at odds with our code, are we constrained by the code? Can we not consider statewide planning goals?
So this depends on, and I have many slides about this later, but it depends on if this is in the legislative context or the quasi judicial context. If the argument is presented in the legislative context, and for example, I can think of one, it might be with the housing code amendments that are making their way through.
Yeah.
A person might make an argument that the code amendments are not compliant with goal 10, which is housing.
Right.
And so, yes, goal 10 does apply directly, or let's say the city has to show that the housing code amendments do comply with goal 10.
Okay.
But if someone comes in for a design review decision, an argument that this isn't consistent with goal 1 is a common one. Sometimes goal 9 comes up. The goals don't apply to those types of quasi-judicial decisions.
Okay.
And it's, it's a little bit hard to keep track of because sometimes you're reading a staff report and you think, well, why isn't there any discussion of the goals? You have to remember which kind of decision this is.
So in other words, if someone has a concern that our code is not compliant, they need to challenge that somewhere besides the quasi judicial process.
If someone has a concern that the code isn't compliant with the
Mhm.
goals, it's too late to challenge that because it is assumed to be compliant with the goals until the non-compliant provisions are amended. And this is this is to provide finality and certainty to all of the participants in the land use process so that they know that the rug can't be pulled out from under them, that they can rely on this code provision as compliant. Otherwise, things would never move along.
So everything that's in our existing code is all assumed to be compliant regardless of our particular feelings of not thinking it meets whatever goals.
It is acknowledged is the legal term. It is acknowledged to comply with the goals.
Okay.
Correct. And that is what LCDC acknowledgement, that's the protection that it gives to cities. Just to go a little bit deeper, initial acknowledgement happened in a very long process with LCDC directly reviewing all of the city's comprehensive plans. The way that comprehensive plan amendments are acknowledged today is through what's called a post-acknowledgement plan amendment, which you'll hear the term pop up all over the place. And it's a little bit different because if there's no appeal, they're deemed acknowledged. So there's not LCDC or DLCD review of it. Someone has to affirmatively challenge them at the time that the code is amended.
Okay.
This might be a land use 201 topic. I'm thinking, all right,
This was very helpful.
yes. So I think we can go to the next slide. Thank you, Jen. So here's slide 3. There's a picture of Governor McCall, and this is just a little background about Senate Bill 100, which was first enacted in 1973. This is what requires comprehensive plans and land use regulations to be reviewed by LCDC and DLCD. The main things about Senate Bill 100 that were very unique were that it, for the first time, it required cities to have urban growth boundaries around their cities to show where the line of development would stop and where resources would be preserved. Most people are pretty familiar with Senate Bill 100 because it's pretty cool. And it was very cutting edge. The impetus for it was, honestly, to both prevent sprawl, but, the flip side of that is to preserve farmland and forest land and other resources. Interestingly, Senate Bill 100 actually first started as Senate Bill 10 in 1969. That did not pass, so it took about 4 years of negotiating before Governor McCall was able to bring it back. This slide is, mainly just a picture of him and to talk about DLCD. Jen, next slide. Or Robert, next slide. Sorry about that. So just a brief breakdown of the goals, because again, the city is going to be looking at some legislative proceedings coming up here. I mean, you're sort of always looking at legislative proceedings, but you have quite a few in the hopper here. So the first set of goals are what I would call the process goals. Goal 1 is citizen involvement. And that is generally embedded in your comprehensive plans, citizen involvement committee. It's the CIC. It's the way that land use decisions are reviewed. Goal 2 is land use planning. That is the PAPA statute that I was talking about. And then we have a category called the resource goals. Those are goals 3, 4, 5 is an important resource goal, and it's important to the city. Here we have scenic areas, open spaces. Interestingly, goal 5 also includes protection for aggregate resources as natural resources. And when I was at Luba, I saw a lot of tension between the goal 5 protection for aggregate resources and the goal 5 protection for other more traditional natural resources. It's something that it sometimes gets missed in our system. The development goals are goal 9, 10, housing, which is a very important one that everyone in the state has been talking about and the governor's focus is on. And goal 11, public facilities, 12, transportation, and then 14 is urbanization. Goal 14 is triggered when the city wants to try to amend or enlarge its urban growth boundary. And it's a very complicated process. That'll be land use 401, I guess. Then we have the important goals for the city, which are the coastal goals, which I'm sure you're pretty familiar with. We've got goal 16, which, you know, the Cannon Beach Municipal Code has, and the comprehensive plan of the code have implemented goal 16 through the code. 17 also, 18 beaches and dunes, and 19, I'm not too sure if there are code provisions that implement ocean resources. More probably need to get back on that. Next slide, please. Thanks. So this slide is about the two kinds of decision making. So we've got our long range planning, let's call it long range planning, big policy planning. Those are your legislative decisions essentially. And then we've got quasi judicial, and they are treated differently from a due process perspective and generally a public participation perspective. So legislative is mostly they're city initiated proposals. It's generally always the city who's filing the application for a legislative amendment to the code. The housing code amendments are a good example. The STR amendments are also a good example. So they typically apply to a large area. They don't affect just one property, or they might apply to a large area of the city, but they're not typically going to affect, you know, 10 properties. Those are political questions. Okay, so generally what happens with those is the planning commission has the first look at these from the planning perspective, takes in a lot of public testimony, often over several hearings to make sure everyone, you know, has a chance to say their thing, and then they make a recommendation to the city council. Then the city council takes it up. City council may also take testimony, hear what the public has to say. All of that gets included in the record. And so at the conclusion of that process, the end result of that is a PAPA, a post-acknowledgement plan amendment. And that is the amendment of the code that is deemed to comply with the statewide planning goals if it's not appealed to LUBA. So because this is a legislative decision, some things that you're really familiar with don't apply. Ex parte contact prohibitions don't apply to legislative proceedings. The concept of bias also doesn't apply to legislative proceedings, because this is it. This is why you're here. This is why you got elected and appointed, is to understand the community's values and translate those into words. So,
Can I ask a question?
yes.
What about the idea of precedent? Decisions made by the planning board based on the language of, which can be general language, you know, specifically objective, but as applied. So a neighbor asks for, well, what have you done in other cases of this, interpreting this word? Is there any interest by the public or others in having any public record of decisions made in similar cases?
So I think, let me break that down. There's no state law or code requirement for a board or the commission or the council even to give precedent to prior decisions. But when the council interprets a provision of the code, that is typically the last word, because of the way your charter works and because the charter places the council at the top of the pyramid. Is that kind of where you were going with
Right,
that?
I just worry sometimes that we need to be consistent in the way we're interpreting things, and with changing membership in committees, where do people go for other, and I know it's case specific, but it would give some credibility to the process if we were as consistent as possible. So it's possible improvements that we could do if we had the manpower.
Mhm.
Yes,
I agree. Consistency is always good.
yeah.
Well, let's put a pin in that one. So, let's see, let's move to the hotter quasi judicial decision making, which is much more what I think all of you are familiar with. So quasi judicial, that's where you have an applicant and they apply and they want to develop or do something with their private property. They file an application, and because it has to do with their property rights, we provide additional due process to the review, and we have that additional due process. We have to have an unbiased decision maker, and we have to have a decision that's based on evidence in the records, so that everyone knows what is on the playing field. So in the quasi judicial context, you're sitting very much like judges, and that is where the term quasi judicial comes from. And this is a very hefty responsibility. So I, definitely want to acknowledge that. So you are sitting like judges, but you're not actually judges. And that's the quasi part. Because in a criminal context, for example, most often the judge probably doesn't know the criminal defendant or the prosecutor well, or they might not live right in the neighborhood. I mean, probably, maybe here they do. But here, the law does acknowledge that, you live in a small community and you know all of your neighbors and you know the piece of property. And I always chuckle because every time the ex parte disclosure part of the hearing comes, everyone says site visit, which is inevitable. But so, to say that if you're completely unbiased, that's very difficult. And the law doesn't require you to be completely unbiased, but it does acknowledge that bias exists, and it wants you to set aside your preconceived notions and just look at the evidence and only make decisions on the evidence that's in the record. So I think, Robert, next slide, please. Thanks. So we've got just a brief overview of the three, really, I left off legislative decision making, but the three quasi judicial review categories here in Cannon Beach are type 1 decisions. And these are the bread and butter decisions that likely none of you really ever see. These are no notice of the application. The notice of the decision only goes to the applicant, and only the applicant can appeal. I do want to flag that applications for the development of housing fall under this category because they are only subject to clear and objective standards. Your most common type here, probably second most common, is type 2 decisions. These are what state law calls limited land use decisions. Here we call them type 2. These are decisions where the uses or the development for which review criteria are reasonably objective, requiring limited discretion. So they're not clear and objective completely, but they are mostly clear and objective, let's say. So for those, no one gets notice of the application, but it's going to be a Jeff decision. Sends notice of the decision to the applicant and the owners of property within 100 feet. Those get appealed to the planning commission and then on to the city council. A de novo hearing is required at the planning commission stage.
And this is the one that I see causing a lot of problems, because if a decision is made administratively and someone who does not live within the required notification area doesn't like the decision, how do they ever know that that decision is getting made so that they can appeal it to the planning commission?
Most of them are posted on the city website, right? They're all on, right? Yeah.
Is that right?
Yeah, they're all like the tree removals, all of those things are all posted on the city website.
A lot of citizens have complained that they don't, they can't spend hours trolling the city website to see every single administrative decision that's made. So then things happen and then they're upset because they didn't know about it, and and it's something they could have appealed, they might miss the appeal window. So how does that get?
So the 100 feet notice area is the floor, and cities can, for most decisions, except for housing, can expand the notice area. So one thing the city could think about doing if in a code amendment, upcoming code amendment package is expand the notice area. I mean, obviously that has budgetary concerns because the more you expand the notice area, the more expensive notices. And as long as you're picking up those people within that 100 feet, you're complying with state law. Yes, I hear you.
So 100 feet is the
That's
minimum
the-
state
Correct.
requirement,
Yes.
and our code just matches with the state.
Yes, the cannabis code matches that. Mhm.
Okay.
But we could make it bigger if we chose to.
Except for housing. That's always, you're gonna hear me say that a lot today.
Why do you
Except
say
for
except for
housing.
housing? In other words, you can't go beyond 100 for housing?
The housing all of the housing laws that have come out of legislature in the last 4 to 5 years really don't want the city to provide notice to anyone of housing developments. And that is, it's not a floor, it's a ceiling. I'll do a whole separate
I'm
housing
sure.
legislation. I'm kind of waiting for session to end and it's like basically
Yeah,
over
because
and then we'll
change.
gather it,
Yeah.
right? So, and then the next type is type 3 decisions. So these are, design review applications are type 3, conditional use applications. And these are the discretionary criteria that you're familiar with, that probably what I need to, talk about the least because these are the things that you see the most. Those are notice of the application, notice of the hearing to owners of record. Your code says 250 feet. Again, that's a floor, that's a city chosen notice area. And those are heard in the first instance by DRB or the planning commission. Those have to be de novo hearings with any opportunity for anyone to come and testify and provide evidence. If appealed, those go to the city council. Let's see, okay. Next slide, please, thanks. Type 4 decisions, these are, this slide I've talked a lot about already, but these are the amendments to the Cannon Beach Municipal Code text or the comprehensive plan. The code says that the council may request the planning commission hearing to consider the proposal and make a recommendation, but I think in practice, the planning commission always is the starting point for these recommendations because of your focus on land use. The council makes the final decision by ordinance. These types of legislative decisions, I mentioned before, DLCD is involved in these types of decisions and requires a certain time period of notice prior to the first hearing before the planning commission, along with the text of the ordinance. DLCD has its own notice list that it gathers and sends out notices that it receives from local governments. So for example, 1000 Friends might be on the DLCD notice list and they might say, I want to receive notice of anything that the city of Cannon Beach is doing with its code. And so they're on the DLCD notice list. They're not on the city's notice list, but that's how they're going to hear about it. For Papa's slightly different appeal timelines, generally they're the same, but slightly different appeal timelines and appeal rights for those to be appealed to LUBA. One thing I want to mention that came up with the housing code amendments is ballot measure 56. This was a statute that was passed by the voters, probably all of you, in 1998. And this requires specific notice to specific property owners when a proposed change to the code might affect the value of their property. That's a very general summary of the wording of the statute. It requires very specific language and it requires a very specific time frame. And I know at one of the hearings that I attended, there was a lot of confusion about why did we get this vague notice that told us to show up at this hearing. And it's a hard thing for people to understand that this is literally what the city has to say. So just in case that comes up again. Okay, next slide, thanks. So, this is the review roles and responsibilities. The couple important things about this slide are just to reiterate, in a type 3 review, the applicant bears the burden of proof. And so they have to produce evidence to demonstrate that the criteria are satisfied. And what that means is that the applicant has to provide the traffic study. It's not the opponent's job to come up with a traffic study that shows that the criteria aren't met. And it's also not the obligation of the planning commission or the DRB to design a project for an applicant so that it meets the criteria. If the applicant doesn't do that, then the application has to be either denied or conditioned in some way to get it across the finish line. Another important aspect of this slide that I wanted to point out is the planning staff's role. And the planning staff role is an important one. They're here to assist all of you as decision makers and to provide the technical advice, and they know the laws, and they are agnostic about proposals. They don't have a dog in the fight. And so that's their role. We also have the role of the public, which in the slide is other nearby property owners, but can generally be the public. Groups like Oregon Coast Alliance or 1,000 Friends, things like that. So they also have an important role. They can be there to identify concerns with a proposal that are within the framework of the applicable criteria. Maybe they can come and they can support a proposal and explain why they think that the criteria aren't met. But land use proceedings are not a popularity contest based on the number of the opponents or the number of supporters. And that leads to your difficult job, right? So finally, the role of the decision maker is that you're going to look at evidence in the record and you're going to determine whether the applicable criteria are met. You sometimes often have to interpret ambiguous provisions of the code. I know it's a lot of pages when you get that 500-page packet that comes to you, and the planning commission has had discussions about why do they have to be so long? Part of that is that our beautiful land use system does have some flaws in that it is a high paper intensive, high evidence burden for applicants. So it's not the fault of the applicant. It's definitely not the fault of planning staff. And also it's not at all fun to read that 500 pages. So let's see. Back to the decision maker role. So, yes. Oh,
I think that's
good notice.
Who does?
looks like Tim.
Oh. Tim, did you have a question?
Yeah, thank you. In the burden of proof question, the design review board had a matter come before us, I think in December and then again in January, if I'm getting that right, where we asked for the applicant to make certain changes to their application. When it came back to us, the applicant was not there. There was no changes in the packet. And I'm guessing that we denied it, but it seemed like the right thing to do at the time, but I'm guessing that they did not meet the burden of proof, and that was the correct response. Can you comment on that briefly?
I want to ask if this is over and it's not on appeal first. Okay.
I don't know if it's within the timeline, that's why.
Yes.
Valerie would know. I wouldn't, to my knowledge, but I don't think it's been appealed.
There may be some aspects that are reappealed,
Mhm.
so it may still
Okay.
continue. Probably continues.
Yes, I mean, I can generally agree with you that the applicant does have the burden of proof, and they have to provide enough evidence to demonstrate that the criteria are met.
Yeah, and being there, and listening to, I think you made the right, I mean, you made an appropriate call. I don't know if it's right or wrong, but you made an appropriate one, you know, as a appointed official, or your body did.
Sorry, I can't provide a better answer to that. I think we can go to the next slide. I do want to, one final thing I want to say here in the role of decision maker is that it's really important that you raise your concerns and ask your questions while the record is open. And I know personally, it's very difficult to think in advance about the questions that you want to ask of an applicant or the participants. But once the record closes and deliberations begin, it's not fair to anyone who's involved in the process to raise new issues that you haven't given anyone a chance to address. And it can also lead to remandable error at LUBA if a person takes it. So that's something that I'm gonna emphasize a few slides later and then a few slides after that too.
So what it amounts to is that we need to support our decisions with some findings.
Mhm.
And if we base our decision during our discussion on a factor that we haven't even discussed with the applicant, that's not fair. Yeah, so we need to think in advance and get the facts so
Yes.
that we can support our findings of fact.
I'm gonna talk about findings
Okay.
specifically in another slide, and that's a great point. So, let's see, Robert, if we could go to, let's see, review procedures. Yes, so we've got, is that slide 10?
Yes.
Okay, so what we're trying to do is we're trying to ensure predictability by having approval criteria that are embedded in the code and everyone knows what the playing field is, and to have a level playing field that's not topsy-turvy. So some state laws set the floor for what the city has to do when it's reviewing quasi-judicial applications. We have completeness review and the 120-day rule. So this is in statute, and it means that the city has to make a decision, a final decision on an application within 120 days. And that 120 days starts the day an application is deemed complete or found complete. So what happens is, I file an application for a conditional use permit. Robert takes a look at it and he checks to see that it checks the boxes, that everything that's supposed to be in an application is included. What he's not doing is saying, this meets the criteria. What he's saying is the application is complete. And once he says that, he sends a letter to the applicant, to me, and then we're off and running. And then the 120-day timeline does start. And so, that is for the full land use, all the land use process. So you can see where, if the planning commission takes, 2 or 3 hearings to reach a planning commission decision on a conditional use permit, that really burns up a lot of time. And it gets the city councils back up against the wall on the appeal end, so that all of a sudden special meetings have to be called. In addition, the city has a unique scope of review on appeal provision, where the city council can decide whether it wants to have an on the record review or a de novo review. And that is it's unique. It's not, good or bad, but what it does is it eats up some additional time in the city council review process as we're barreling towards that 120-day time limit. And so that's something that the council, might want to take a look at, sort of tightening down the council review procedure. But I think it's actually a good procedure to have, rather than making everything an on the record review, because it gives the council a chance to correct potential procedural errors that might have accidentally happened. That's a topic for another, a long topic that we can cover another time. So
Is the on the record review the standard typical like other cities, that's the non-weird way that automatically in a lot of cities it operates.
I would say more cities than not, but you know, I just got done.
Without the additional like choice of.
Yes, without the additional choice of having a de novo review, right? A lot of cities and counties do a hybrid, like the city does, and, you know, there's no easy solution to this. Counties I would say have more, de novo review, but they get 150 days. I don't know why, because they're special, but, and that, it seems unfair. So a couple other things is, we have to give 20 days in advance notice of the hearing, and we have to provide a staff report at least 7 days before the hearing. Another state law requirement is the hearing script. So at the opening of the hearing, you are all familiar with the little script that the chair has to read, and it's so interesting, it's riveting. And everybody just immediately is like on the edge of their seats, waiting to see what's gonna happen, but it's required by state law, and the city doesn't have a choice, and the key components of that are their instructions to the participants that any evidence that they want to be included in the record has to be submitted to the city. They gotta hand it to Robert or Jeff, or it's not gonna be in the record. So that means if they have a poster board and they want it in the record, they have to hand it over, and the city takes charge of that. You know, I guess it could mean like if somebody points to their shirt as a demonstration of evidence, they're gonna need to leave their shirt. I don't know.
We'll take the shirt off their
Yeah,
back.
Robert, if you could go to the next slide, which is the fixed goalpost rule. So there's a state law that freezes the standards and criteria that are in effect as of the date the application is filed. And, that's right, I forgot I put that in the slide. So this means, sometimes this means if the city is contemplating big changes to its code or some changes to its code, and one thing I can think of is the STR amendments that are under discussion right now. Sometimes that leads to a flurry of activity and a flurry of applications where the property owners want to get them in before the code changes. And they do, as long as that application is complete and Robert can check all the boxes, the goalpost is fixed. One example that I was thinking of on my way here was that which we're not going to really get into, but the application in the Roberts case, which I think was submitted many years ago, that's a fixed goalpost, even though it's been up to LUBA and then to the Court of Appeals, and it's still sitting at the Supreme Court. So that's the fixed goalpost rule is quite powerful for applicants. Testimony has to be directed to the criteria. This is one, I think it's hard for people to understand. So as an example, I might want to develop a new school. And so one thing I'm going to do is I'm going to bring all of the students and all of the parents that would benefit from the new school. And they're going to talk about how great this new school would be. But there's really never a criterion that says, is this a great idea, right? The criteria are about what are the traffic impacts, and is the sewer pipe big enough for the new school, and is there water to the new school? It's not whether is the school a good idea. But when you're hearing testimony and all of testimony is this is a good idea, this is a bad idea, it is easy to forget that that's not really what land use cares about. What land use cares about is the impacts, right? The impacts on industry, and mostly industry. So then your job is really only to apply the standards, and it's very difficult to ignore the smiling faces of school children, but that's what the job requires. It's not about whether it's a good proposal or a bad proposal. So little bit of, let's see, on Robert, can you go to the next slide? Okay. So, one of the other, required announcements in the hearing script, the fascinating hearing script is the announcement about raise it or waive it. And that means that in order to preserve an argument on appeal, you have to raise it. You have to give the city planning commission, DRB, or the city council fair notice of the issue that you're raising. And that's because the law and the way our land use program is structured wants to give the local government the first and probably only chance, hopefully, at addressing this issue. It doesn't want this issue to be first decided by an appeal body that doesn't have an investment in the community. So, you know, raise it or waive it is a good thing. It's a slow narrowing of the issues so that by the time the issues do get presented to LUBA, if that's the case, everyone knows what the issues are. There are a few exceptions, right? Like everything in the law has exceptions, but generally that's what raise or waive it means. Also you have to raise also with raise it or waive it, you have to raise constitutional issues before the local government. You cannot go to LUBA and sandbag a local government and raise a takings issue, which is also a good thing. Those are important ones to consider. Also, at the beginning of, at the end of the first hearing, any party has the right to request a continuance. The city can handle that in one of two ways. It can actually continue the hearing, or it can leave the record open. And that's a typical timeframe where the record is open for 7 days. And I call it the ollie oxen free period. And then the next 7 days is responding only to what came in during the ollie oxen free period. And then the applicant always gets a final 7 days for its written arguments. Continuances work better for cities that have very, very frequent hearings on the calendar. So for example, if you have a planning commission and you meet twice a month, and maybe you meet every 2 Thursdays a month, it's a lot easier to continue the hearing to a regularly scheduled hearing. In that circumstance, it's much harder if you are a once a month planning commission because you're eating up 28 days of that 120 days. And then you still might have to leave the record open depending on what happens. And so that's why typically your attorney will recommend a written open record period rather than a continuance of the hearing. Okay, thank you, Robert. I'm on slide 13, right? Okay, let's talk again about the 120-day rule. So it's a really big deal. The applicant controls the completeness, and they can force the city to begin processing an application, even if the city views that it's not complete, by forcing completeness, and then the 120 days starts. What happens if the city doesn't meet the 120 days? This applicant can go to circuit court on a day 121, and they can seek a writ of mandamus, and the burden flips in that circumstance. And what happens is it's incumbent on the city then to prove that the application does not meet the criteria. And the main danger of getting hauled into a mandamus proceeding is that if the city loses, they are obligated to pay the applicant's attorney fees, and the most significant, and refund at least 50% of the application fee, which is like peanuts compared to the attorney fees, but still. Are there any questions about the 120-day rule? Okay. The applicant can extend the 120 days for a pretty significant length of time, up to 245 days. And that is often a really good solution because gets the applicant and the city kind of working in the same direction to get to a yes. And that's more often than not, an applicant will extend if it looks like they can get to a yes. This is slide 14. Thank you. So, everyone involved in the land use process has the right to an impartial tribunal. Never gonna get through on this slide. I'm so sorry.
We can do 201.
Yes, 201. I like it. That means that, you're all familiar with ex parte disclosures. So I think we can go to the next slide, Robert. I wanted to talk a little bit about, actually, Robert, I'm going to skip a couple here too, because this is just sort of background that you can read at your leisure. So we've got a few cases of bias that I wanted to talk about. You could stop, thanks. So, Friends of Jacksonville, that's one of the only bias cases that actually has gone up to the Court of Appeals and been affirmed. So in the world, it's considered real strong precedent. What happened there was a city councilor who was a member of a church that wanted to expand, and build an annex, signed a petition when he was on the city council, supporting the church's application. And then prior to the deliberations, he also entered into the record a lengthy document explaining why he believed that the application met the approval criteria. And some people, Friends of Jacksonville, was not happy with the lack of impartiality and appealed that to LUBA. LUBA agreed that this counselor had prejudged the matter to such an extent that he should have recused himself from participating. Bias is the standard for bias is that actual bias. And so it's not a sort of biases in the air feeling. It's a real serious statement on the record in writing that shows that a decision maker cannot properly view the evidence and apply it to the criteria. Your code, has a separate internal process for a bias challenge where the planning commission or the city council actually takes a vote on whether the person is biased, which I have not seen in other codes, but it's pretty cool. So let's go to slide 23. These are my quick let's see, 24 maybe? But I'm so sorry. Slide 20. Robert, thank you. These are my quick recommendations for effective participation. First thing is anything that you can do to read the packet in advance is so helpful. I mean, this is why you get paid the big bucks, right? Is to read that 500 pages. Okay. So if you have questions, you can ask staff in advance and just try to be as prepared as you can. Also, I just want to note, as you all know, it takes a lot of courage to get up and speak in public at a proceeding. And I think it's important to treat all the participants with respect and professionalism, acknowledging that they also share the community's values, but they just might have a different take on it. Slide 22, and then I'm going to be quiet. Let's keep talking. Just wanted to flag again the importance of getting your questions asked while the record is open. That goes hand in hand with really trying to read the packet and think of your questions in advance, because it's not the time for asking questions of the applicant or the participants is not during deliberations. It's also not the time to, think about for the first time and articulate whether some standard that no one's ever talked about applies. That is just going to get the city into procedural trouble. And I think I'm going to stop here so that you all can stay on schedule.
Just point out.
Yes.
Out the adequate findings.
Yes, okay. That is really great. Oh, yeah, that's right. So this is something that most commissioners and counselors don't really know, but the requirement for adequate findings, what LUBA reviews is only the written findings. And so because think about it, most people are lay people, not everybody, but most people are lay people, and try hard as we might to articulate the legal reasons for why the criteria are not met. LUBA doesn't require that verbal articulation out loud at the hearing. It reviews the written findings that are typically prepared later or before by staff, and sometimes with the involvement of the city's attorneys. So that's why a lot of times maybe the discussion during deliberations that you recall isn't quite as precise as what comes out in the written findings. And it's because the staff takes those discussions and they place them into the land use world and the land use language and produces written findings that, memorialize the discussion so that LUBA can understand what the discussion is. Hopefully it doesn't go to LUBA. but that's,
But you still, as drafters of those findings, need to be able to point back to the deliberations, correct? Like you can't whole cloth. This is what they really meant. We need as a body to cover each criterion and have.
there is no state law requirement memorializing what you just said.
Really? Okay.
So if that's true, then whoever is drafting the findings can just decide what they think would be the appropriate. I mean, if you can't.
Well, so the findings come back though to the decision-making body for approval, and so. You know, there have been times where the decision-making body, then they look at the findings and they say, well, no, I don't think that's right, and then there's sort of another vote, it's not the same. As the tentative oral decision, but there's always a second chance for the governing body they have to approve the findings.
Right, and then they'd have to have the record of everything that was said with, you know, in order to point to something in the record. I mean, that really bothers me because it seems like, you know, usually I would think that findings would be based on things you could point to in the record. And if you don't have that requirement, then that seems to give a lot of, flexibility, I guess is a nice way of saying it, to the person who's writing the findings. And if it comes back in front of, for approval, at that point in time, it's very hard to know what's in, you know, exactly what in the record you could point to. Well, I don't remember us making findings specifically about the number of feet from A, B, C, you know, whether, and so there you have these findings that are adequate for LUBA because they're usually prepared by an attorney who knows what they're doing. So they're, you know, really good findings, but they may not really, they may be putting words into the mouths of the decision maker that really.
May not reflect.
Right, because the decision maker didn't have the knowledge.
But would
To
it have
even make
changed
the
the decision of the committee?
So that's, I think the question is, there's the balance between having a decision that is sustainable at LUBA that does reflect the vote that occurred, right? Maybe if it was like 4-3 or something like that. And that's really a decision for the city to make, because if the city wants to send inadequate findings up to LUBA, that's gonna cost the city a lot of money, right? But if the city really doesn't, you know, the other thing that's gonna happen in that circumstance is you're all gonna be here deliberating at a level that is potentially not what anyone expected to be deliberating at, right? And I'm gonna be sitting there being mean, and I'm gonna have to say, like, can you please expand on your discussion of this criterion, and you know, you're gonna all be mad at me because it's gonna be like 10:30 at night.
And well, it's.
So it's a balance.
But
It's a
it is
balance.
balance. And I'll tell you, from working in different jurisdictions, you know, some places I've worked, we go criteria by criteria, go down, and they reference, you know, we don't go move to the next one until we get done with that one. I mean, I've been to that level, and then, you know, I've been, I would say this is more jazz, freeform, you know. But there's a huge balance, but I think the appropriate, and then like here, you know, I will draft it, and if it's kind of a dicey one, and I know there's gonna be challenges, I will often give it to a Missy or
Gary.
Bill or Gary or whoever, but before we come back to you guys, but, you know, we try to find that as staff too, that balance, because, you know, like you said, we know certain things that need to be in there, that, you know, may not have been really said in that record, but it's been brought up in the discussion that others are, you know, part of that, or it comes from the staff report, and that's another thing. A lot of jurisdictions will say, we will adopt, this, 14B, as written. And then, you know, so they'll go move through the staff report to that level in certain places I've worked and adopt that very word into the findings, and that's what they want.
And which is totally a legitimate choice, right?
So would it be best practice for us to spend more time with each application, looking at the criteria and having an organized conversation around do we as a body agree with 1A, 2B?
That is, it's up to you guys.
I think that would help the whole process be less onerous after the
sure.
fact.
Yeah.
To deliberate in that manner so that we can, bullet point by bullet point, say this is the reason we're making the decisions that we're making. And it would make it easier for staff and everybody else on down the line, and for the appeals, for, the council and so forth. Yeah.
Well, it could also make it easier for, newer planning commissioners to understand we're gonna hit these criteria as we go through.
Yeah.
Agreed.
And one of the things I appreciate about our staff is that when you remind us of what we haven't made a finding on, you don't make it a leading question. Well, didn't you mean to say this? So you have to keep it balanced and give everybody a chance to weigh in on what these criteria are. So that's very professional. Appreciate it.
Yeah, when the succinctness starts at the committee or the, commissioner level, then that carries through a lot easier, I think.
Yeah, so I think that's a good idea.
Yeah.
I would like to see an expansion of the, examining the criteria and laying it out so that you don't end up getting a findings of fact. We thought, gee, I didn't say that. I wouldn't even know to say that, I mean,
Oh, and
Well, I also think it
oftentimes-
makes it easier for us,
yeah.
because we don't get into a moral conversation. We can stay focused on the criteria, and we don't have to bring in, is this a good idea or a bad idea? It's just read the criteria and how does this apply?
Oftentimes in, the report or the staff report, they will identify certain codes and standards and, for our assessment.
Our motions would be more precise as well.
Yeah.
Because we just,
Yes.
based on this information here, this information here. And we want to
That'd be
see
so much better.
repeating ourselves,
Exactly.
motion, we can say, okay, we need to change, bullet point.
Yeah.
And for the council as well. I mean, I
Yeah.
want to see that expansion on the council's position because there's been times when I haven't recognized the findings from what I remember the discussion. being.
What if there's different understandings about an ordinance and how to interpret it in a file?
Well, so generally, the city has a large arrow in its quiver in that the city council's interpretations of the code get extreme deference from LUBA. A lot of deference, and it's very rare that they're overturned. The decision makers' determinations about credibility of the evidence, so if you have two competing traffic studies, the decision maker's determination about the credibility of evidence also gets a ton of deference at LUBA, and so often the findings will include, we want, once the city has made a decision, I think the city really does want to defend that decision, right? And so we want to use all the arrows in the quiver, and so the findings will include an interpretation that is almost certain to be sustained. And it'll include a credibility determination based on the obvious outcome of the vote, right? Even though maybe that wasn't exactly discussed, those are all things that really solidify and make a stronger decision, and a decision that's much more likely to be upheld on appeal. And then, which means cost the city a lot less money, so.
But that's not the goal.
So,
Is that the whole goal of this to be upheld on appeal and not cost the city money? I mean,
I think that's for you all to, it's really for the council to decide,
I'm sorry, but we are now moving into.
Oh, yes.
The next.
I mean, I
want
I
to thank
can
Missy for,
There's no obvious.
thank Missy for coming and.
We're all on it.
serving for the-
Thank you.
Yeah.
Thank you so much. It's really nice to see you all. See you all.
Yes.
Oh, the meeting is adjourned. Oh.
Yeah.
Are you still?